Day, everybody. Bye-bye.
All right, Wyatt Faria and then Ronald Campbell. I was speak as appropriate.
Your Honor, state is seeking $10,000 in bail for Mr. Faria's case. We're also seeking pretrial services supervision with a no contact order with the victim, as well as a no firearms or weapons clause. That is based on the violence outlined in the probable cause declaration, as well as he does score moderate on the risk assessment at a 7. We know that he resides out of the state in Susanville, California. He has a domestic battery pending in Reno Municipal Court. It is against the same victim. It appears to be from a different date than this because the case number is different. He was arrested on that as well as this case at the same time. He has a prior felony conviction from 2024, a grand theft and receiving known stolen property. Those are out of California. He looks like he originally got probation on those offenses and then was sent to prison for a violation in 2025. Defendant's only 22 years of age and has already accumulated that history. So based on that and his lack of ties to our community, the state does believe that $10,000 and no contact and no firearms is appropriate. We did attempt to reach out to the victim. Unfortunately, we didn't hear back from her before this morning, and I will submit it on that.
Okay, thank you, Ms. Lopez.
Your Honor, Mr. Faria would go to CARES most likely if he were to be released. We have people that go to CARES potentially as often as weekly, but at least we have a memorandum of understanding with CARES campus. We can keep track of him and remind him of court dates and stay up to date. Besides that, Your Honor, Mr. Faria indicates that he would be willing and able to come back to court, that he understands the requirements of supervision and would be able to comply with those. Whatever amount of bail that this court imposes is going to be a de facto no bail hold for Mr. Faria. He doesn't have any money that he can use to apply towards bail. We did speak to his father. His father told us that he is indigent and doesn't have any money that he can afford to contribute either. And so for those reasons, we are asking for the court to consider not just the underlying charge, but also Mr. Faria's ability to pay, and the other factors when determining what's appropriate. We would be asking for an own recognizance release with supervision and no contact with the named victims.
All right, thank you. Given the allegation of 2 domestic batteries in a short period of time, and then the seriousness of the threat to the victim posed by the facts of this case, the state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. So if it comes out that that is not a separate domestic, then I'll certainly give you a new bail hearing without having to file a motion. If for some reason those are the same facts and circumstances and they just did a misdemeanor there and a felony here for some reason. The bail we said as requested, $10,000, no contact, separate criminal offense pursuant to NRS 178-445, the maximum 120 days, no firearms, pretrial services supervision, no bail laws, make all court appearances. We'll see him for the filing of the criminal complaint on the 27th.
24th.
Sorry, 24th. 24th at 9:30 a.m.
All right, so you can head back.
Thank you. Campbell and then Lopez. Come on, Mr. Campbell, would you like to apply for the services of the public defender?
Your Honor, Mr. Campbell is hard of hearing. We also already represent Mr. Campbell in competency court.
All right, then I've appointed the public defender. What would you like to do today since he's in competency court?
I would like to reset this, Your Honor, to Wednesday.
All right, July 22nd.
Do you want to do an interim bail?
Yes.
All right.
Well, Judge,
So it's being set over to July 22nd at 9:30. What's the interim bail the state request?
Your Honor, the state will request $1,000 in bail.
That'll be the order. We'll see you Wednesday.
Okay, Campbell. Campbell. All right, Campbell.
He can't hear you.
Wednesday. All right, so he's gonna have to stay on one hearing on Wednesday.
No, it's for us to file an AD and SB 89 and kick it over to competency.
Pedro Lopez and then Vincent McDade. We have two matters for Mr. Lopez. Let's do the arraignment first.
I don't have,
Okay,
I sent the complaint up this morning to the jail.
you have it.
It's a no jail complaint. I can resend it.
Can we trail it then perhaps?
sure. Yeah, have a seat, Mr. Lopez. We'll be with you in a moment. Vincent McDade and then Rudolph Vigil. What state feels appropriate on Mr. McDade's case?
Your Honor, we are seeking $20,000 for Mr. McDade. That is based on the facts of the case. His high risk assessment at 11. You can see he got 1 point for failure to appear. He did have a bench warrant or has a bench warrant issued for failure to comply with a Reno Municipal Court case. That his criminal history is 2026, possession of drug paraphernalia out of this court. He's got a trespassing out of Reno Municipal Court from this year. That is what that failure to comply warrant is. Oh, I'm sorry. No, that one, he did fail to appear on that case, but they have not issued a warrant yet. So that's sort of pending. In 2025, he was convicted on driving on a revoked driver's license. That is the one that has the failure to comply post-sentence warrant issued to it. He also failed to appear pre-sentence in that case as well. So we should have more points for failures to appear. He has felony conviction in 2022 for carrying a concealed weapon. That's out of our 8th Judicial District Court. He's got another felony conviction in 2018 for owning a gun by a prohibited person out of Las Vegas, a DUI out of Las Vegas, and then 2 more felonies, transporting a controlled substance back in 2010, and another one in 1998. Both of those look like they're out of California, and then a series of felonies for robbery, receiving or known stolen property, and burglary, all back in the 80s. So the defendant continues to commit criminal conduct. This is a higher amount of controlled substance, 11 grams. I talked to Officer Jager last night. These controlled substances were found in a bag with the defendant's wallet and his ID in them as well. So the state does believe the proof is strong in the case. So we are seeking that $20,000 with pretrial services and testing as a condition.
All right, thank you, defense.
Your Honor, despite the fact that it was, allegedly found in a bag with his wallet in it, he was also found with a co-defendant who had paraphernalia on her person. So there is a colorable argument that it was hers. Nevertheless, looking at this with it being a nonviolent offense related to controlled substances use, and with the substance that is alleged, I believe that Mr. McDade might be a good candidate for the STAR program. So I would ask if the court would be willing to begin the PSS process so that Mr. McDade can be assessed to see if he is a good candidate. If that is the case, we would ask that he be permitted to, through IAP transport, go to an inpatient treatment facility. This is, again, nonviolent offense. He was found sleeping in a car in a high crime area, whatever that means. And it's just possession of controlled substances that were in the vehicle that he was sleeping in.
All right, I will release him to residential treatment if an evaluation supports that level of treatment. I'll also refer him to the STAR program.
That PSS date will be July 21st at 10:30.
But without those least restrictive means, the state's shown by clear convincing it that there needs to be bail in this case to ensure the safety of the community and appearance of the defendant. So we set at $20,000, random drug testing, pretrial supervision. Again, I'm referring him to the STAR program and also releasing him to residential treatment with IAP transport if the evaluation supports that level of treatment. July 24th at 9:30 a.m. is the defendant's next court date. Vigil and then Fryman.
The day after tomorrow.
What does the state feels appropriate on this matter?
Your Honor, state's seeking $15,000 for the defendant along with pretrial services and supervision. Not unlike the last case, this defendant also has a high risk assessment here. The amount of the controlled substances is a little bit less. However, very lengthy criminal history starting back in the 80s. Those are misdemeanors. Once we get to the 90s, we see felony convictions for petty theft with a prior, robbery, first degree, possession of a controlled substance, false or forged checks, all of those out of California, 90s, early 2000s. Has another, a misdemeanor conviction for manufacturing dangerous weapons in 2007 and evading in 2010. Those are all out of California. His history starts here in 2011 with a felony conviction for battery with a deadly weapon. In 2011, 2017, possession of stolen property felony. And then he has misdemeanors starting in 2024 for it looks like possession of drug paraphernalia out of Reno Municipal Court, 2 different failures to appear associated to that case. 2025, he's convicted of lying on a sidewalk out of Reno Municipal Court. Again, he fails to appear at a community court hearing in that case, and a bench warrant had to be issued for his arrest, which he eventually admitted. Conviction for possession of drug paraphernalia last year in Reno Justice Court. And then just this year, again, a citation for sitting, lying, sleeping on public sidewalk. That is currently pending in Reno Municipal Court. It shows he was supposed to be arraigned on July 7th. Doesn't show whether he showed up or not. No warrant has issued for him on that case yet. He also has another trespassing citation this year from Reno Municipal Court. That one did have a failure to appear at arraignment, and a bench warrant was issued for his arrest. So certainly has recent compliance issues, very lengthy criminal history. For those reasons, $15,000 with pretrial services and testing.
All right, thank you. Defense.
Importantly, Your Honor, Mr. Vigil doesn't score for violent offenses in the past 10 years. And that battery with a deadly weapon on the NCIC that was discovered to me by the state, it shows no disposition, not a conviction. So it's possible that it's been even longer that he has stayed out of violent trouble. The most recent involvements with the police or with law enforcement involve him being unhoused and not having stable housing. Sitting, lying, camping in the sidewalk, and obviously some possession of controlled substance paraphernalia. This is obviously a case where Mr. Vigil struggles with substance use, and he struggles to get around because he doesn't have, a phone or transportation or any reminders to help him get back to court or understand what day it is. Nevertheless, we are confident that if Mr. Vigil were to be engaged in treatment, some of those concerns would be alleviated. Based on the PC sheet itself, it doesn't look like Mr. Vigil might be a candidate for STAR, but he might be a candidate for some other therapeutic court. So we are also asking for the PSS in this case to see if Mr. Vigil would be a good candidate for an inpatient program, and to see if there are other conditions that the court can impose that would not involve staying in custody on a non-violent possession offense that may or may not even be charged as a felony.
All right. That treatment certainly, if done appropriately, would likely significantly reduce the risk the defendant poses to the community. So I think I'm compelled to consider it. The bill will be $15,000, random drug testing, pretrial service supervision, PSS with RJC, and she's going to give me the date while I write the rest of this.
So not STAR program.
Correct.
So we can do pre-screening with the CAP court July 27th at 1:30.
And like the last one, I'm right. So PSS with RJC and okay to release with IEP and residential treatment if eval supports.
Thank you, Your
Next
Honor.
court date is July 24th at 9:30. You're welcome.
All right, Vigil.
Ryman and then Haley. All right, what the state feels appropriate on this matter?
Your Honor, we are seeking a one-day continuance in order to comply with Marcy's law. We did attempt to make contact with the victim this morning, but unclear if we have the right phone number or not. So we are seeking a one-day continuance.
All right, we'll see you back tomorrow, sir.
We'll get in touch with,
Haley and then Harris.
so tomorrow.
All right, what does the state feels appropriate on this matter?
Your Honor, we're seeking $5,000 bail. Not seeking any conditions at this point. He scores a 12 on the risk assessment. We know the defendant's on parole. That parole is out of, looks like it's an interstate compact out of Idaho from a conviction in 2023 for forgery. He is on that parole. It says it ends in 2033. So he has a very extensive parole. Again, that was a 2023 conviction. He has been convicted of a DUI since then in 2025 out of our jurisdiction. Prior to that, he has convictions for burglary and attempted robbery out of our jurisdiction in 2019. And then misdemeanors, possession of drug paraphernalia, and a domestic battery, 1 in 15 and 1 in 2013. But based on the amount of the controlled substances located here, as well as his parole hold, we're asking for a $5,000 bail.
All right, thank you, defense.
Your Honor, we're asking for this court to consider releasing Mr. Haley on his own recognizance. This was a very unfortunate misunderstanding. I'm sure the court read the PC sheet that he was going back for his backpack and somebody just misunderstood what he was doing there. Appears to be the first violation of that parole. So what he really needs to do is go and explain the circumstances and hopefully be returned. He was there, which was a job site. So he is employed. He is also supposed to be starting a new job on Monday. We confirmed that with his girlfriend, Tiffany, and his best friend, Darius, both. So if the court feels because of the likelihood that he's going to be transported to another jurisdiction that some amount of bail is appropriate, we would ask that the court impose $1,000 bondable, considering that probably this wouldn't have happened if he had just been recognized or had texted somebody that he was on his way.
I didn't have a phone, like everything, I didn't have anything. I had no way to.
All right, I appreciate that, but the issue is he has a felony while on parole and he scores a higher risk to reoffend. So the state shown by clear and convincing him the bail is necessary to ensure the safety of the community and the appearance of the defendant. It'll be set at $5,000 pretrial services monitoring only, July 24th at 9:30 a.m. This is probably going to get results pretty soon, sir, and then you'll be back up in Idaho.
Okay.
Thank you. Harris and then Munoz.
Your Honor, Mr. Harris was not able to make it to court today. I'm not sure why. So if we could continue this to tomorrow to see if
Sure,
he's
of course.
ill.
Munoz and then Grant.
Complaint forms.
What does the state feels appropriate on this matter?
Your state seeking $65,000 in bail for Mr. Munoz, along with pretrial services and testing for controlled substances. Mr. Munoz, first of all, the proof in the case is great based on the defendant being seen on surveillance video appears to be stealing the car and then being in possession of that vehicle and the keys. He scores high on the risk assessment at 13. Maybe most importantly is that the defendant is pending 2 different felony cases out of the 2nd Judicial District Court. He just pled guilty to vehicle burglary and out of our to possession of stolen property out of the 2nd Judicial District Court. He's pending sentencing in that case. He also had, while he was on pretrial for that case, picked up a possession of a controlled substance felony. That one also is in 2nd Judicial District Court. Negotiations where that would be dismissed upon sentencing in the possession of stolen property case. Unfortunately for him, he stopped checking in on both of those cases. They did an order to show cause. He didn't show up. Pretrial couldn't get a hold of him, so they issued warrants for both of those cases. He also has felony convictions for possession of stolen motor vehicle in 2024 out of Lyon County, it looks like. He's got a felony possession of a firearm conviction in 2022 He's got an evading felony in 2021, assault with a deadly weapon felony in 2015, a domestic battery felony in 2012, and then a bunch of misdemeanors in there as well. So defendant continues to commit criminal activity, whether he's on pretrial supervision, in some of those cases while on parole. So the state believes that a higher bail is appropriate with those conditions.
All right, thank you, defense.
A higher bail, Your Honor, is not necessary to keep Mr. Munoz in custody, particularly considering that he has this no bail hold out of the Second Judicial District Court, and that hold is not likely to be lifted. The bail that he had previously posted has been forfeited. In this case, Your Honor, I understand that it is a new theft offense and that he was allegedly in possession of a controlled substance. I would note that this is a non-violent offense. He is alleged to have taken a car that was sitting unattended rather than, taking it from somebody with somebody present. So for those reasons, I would ask that the court consider setting a more modest bail for Mr. Munoz, particularly considering, again, that no bail hold is going to detain him for a lengthy period of time.
All right, thank you. I believe the state's shown by clear and convincing evidence the bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. In fact, the defendant's behavior is what has shown that. He had $6,500 bail and possession of stolen property, burglary of a motor vehicle case out of Sparks. He posted that, and then, as the state pointed out, went on to commit two separate felonies on separate occasions, months apart. So he's clearly a great risk to the community, and the only thing that will address that is bail outside his ability to make it. It'll be set at $65,000, random drug and alcohol testing, pretrial service supervision, obey laws, make court offenses, July 24th at 9:30 a.m. to defense next court date. We'll see you back then. Grant.
Actually,
Lopez.
Mr. Lopez.
So Lopez and then Grant. All right, let's do the arraignment.
For this one,
For this. Yeah, the new one.
this one wasn't one.
Your Honor, Mr. Lopez has a copy of his criminal complaint. His name is spelled correctly on line 9 of the document. He understands the charges it relates to him, count 1. He will enter a not guilty plea. He does currently have another bail out of this court, $500 bondable. That case is with the alternate public defender's office, so I don't have any information on it.
Was that this case? Is this APD?
Oh, this is an APD.
All right, this is an APD case. So yeah, we'll enter that not guilty plea and we'll see him Tuesday for an MSC at 9 a.m. That's the 21st of July. Let's talk about bail on the new case. What does the state feel is appropriate?
Your Honor, we are seeking $50,000 bail on Mr. Lopez's case. Again, this is a possession of a controlled substance over 42 grams. It is a category B offense. Those drugs were found in each one of his pockets when he was stopped. He scores a 9 on the risk assessment. He's only 19 years of age. We obviously just saw that other case, which he was originally arrested on a felony possession of a controlled substance, charged as a misdemeanor. Unfortunately for Mr. Lopez, he was given an OR in that case with pretrial services supervision and testing. He didn't show up. He didn't show up at arraignment, and the bench warrant went out for his arrest. So he's clearly shown to this court that he is a risk not to appear. In addition to that case, in 2025, he was convicted of obstructing and resisting, providing false identification to a police officer out of Reno Municipal Court. He also was convicted of driving when his driving privileges were suspended or revoked out of Reno Municipal Court. He was supposed to show up to those cases and provide proof of certain elements post-sentence. He did neither of those, and a bench warrant had to be issued for his arrest in those cases. He has a lengthy juvenile history, including being on parole prior to his adult criminal history starting. So for all of those reasons, we do believe a higher bail is appropriate. We'd also seek pretrial services supervision and testing for controlled substances.
All right, thank you. Defense?
Your Honor, we are asking that the court consider re-releasing Mr. Lopez on his own recognizance, and in large part, it has to do with his age. I'm sure the court is well aware that having somebody this young in the jail increases his risk of reoffending rather than decreasing it. There are conditions that we could impose on Mr. Lopez that would mitigate his risk of failing to appear. It looks like last time he was released with very few conditions. I think that this time, if he were to be released with weekly check-in and with some homework to do, perhaps he could get started on getting an evaluation and go to some self-helps and turn those in weekly. That would not only go towards, mitigating the risk of reoffending in the community and being in possession of controlled substances again, but it would also mitigate the risk of him failing to appear for court. We reached out to his girlfriend, Star. She verified an address for us, and she verified a phone number and a job. He is employed doing construction cleanup. He's got a good phone number. She says that he has a good support system and he will follow through with court requirements, especially this time. It doesn't sound like he has been stable for that long, but he is on the path out of this, and we want to support that rather than pull the rug out from under him right at the time that he's starting his life. So for those reasons, we are asking that the court consider releasing him with supervision because those conditions can be less restrictive than holding him in custody.
All right, thank you. Well, I certainly agree with everything you've said with regards to the consequences of incarcerating someone of his age at this point. However, if I look back in that other case that we just arraigned him on, pretrial services had overrode him to a higher to reoffend, and it looks like their concerns were accurate. He was put on random drug testing and pretrial service supervision and no contact with the co-defendants, and he's back before us on serious felony charges. And so yes, unfortunately, there will be consequences to the community and him and his life and his family for this alleged action. But in balancing those interests, the state's compelling interest in public safety and the defendant appearing, I have to set bail because we tried releasing him with treatment before and we were unsuccessful. We can't do anything for somebody who won't show up. Bail will be $50,000, no drug or alcohol, random testing, pretrial service supervision, no bail laws, medical court appearance. July 24th at 9:30 is his next court date on this matter. Good luck to you, sir. All right, Grant, are we doing that today?
Yes, Your Honor. Or we're ready anyway.
Oh, I think you're going in there. Not strong enough, probably. It's like some healthy thing. Overdid it this week. Every time I overdo it. All right, first question for you, Mr. Grant. You said you're going to hire your own attorney. Is that still the case?
Yes, at the nation's finest, most military veterans utilize them.
Sorry, I didn't understand that. Can you come forward a little bit and say that a little clearer?
Nation's Finest is an office that helps veterans in situations like mine, and they give us legal counsel and representation. So I'm going to make contact with him tomorrow.
Okay. Other than that, do you have money to hire an attorney?
Yes and no. I mean, I can't afford it that way, but if I have to, I'll do what I can.
Tell me how much money you have.
I have $500 for bail right now, and
500?
500, yes, sir. And
right.
with regards to the attorneys, they have taken care of myself because I'm 100% veterans qualified for benefits, and so they will help me get through this situation.
So no, let's assume they deny you just for argument purposes.
Sure.
But they say we're not cover this type of a case. Then what money do you have to hire an attorney?
Well, then my most likely remedy would be probably go get a public defender.
Right, but I'm trying to address that now. I'm gonna ask it one, hopefully last time. Please tell me how much money you have to hire an attorney.
$1,000 basically.
All right, you live in an apartment, right? It was an apartment where
Yes.
you live. And you have $1,000 that you could get together, is the most.
Yes.
All right, well, I'm gonna point you to the public defender. If this other organization wants to come in and substitute in and represent you, they certainly can. We'll go
Okay.
forward today. What does the state feels appropriate?
Thank you, Your Honor. State seeking $300,000 bail in Mr. Grant's case. That would be with no 10% cash alternative. Based on the serious nature of these offenses, one of them being a category A life offense. Although he scores 4 on the risk assessment, the facts of this case are egregious. 2 different minor victims who were victimized at the hands of the defendant, basically caught red-handed by sounds like the boyfriend of the mother of one of those victims. Those victims were interviewed, gave statements supporting sexual acts in this case, in addition to providing them alcohol, smoking marijuana with them. He does have 2 prior felony convictions. They're old, back in 2002, uttering a forged prescription out of Washington. And then he's got felony conviction for larceny back in 1997 out of Washington, and theft, gross misdemeanor out of Washington, and a conviction for public health laws. I'm not sure what that is, but it's a felony out of Washington. So again, based on the community safety risk for taking advantage of, I believe it was a 14 and a 15-year-old in this case, and the very, first of all, the good evidence in the case, as well as likelihood of conviction in this matter, the state believes that the $300,000, along with pretrial services supervision, we would also ask for house arrest and GPS based on community safety reasons. No contact order with both of those minor children. No firearms or weapons, and a no alcohol or controlled substance clause and testing for both of those. Unfortunately, we did reach out to the victim yesterday, the victim's parent. The only information that we have, left a message, but we have not heard back from mom yet. So we're going forward today without unfortunate victim guardian input.
All right, thank you, defense.
Your Honor, we're asking this court to give Mr. Grant an opportunity to be released on his own recognizance. We do understand how serious these allegations are. However, there are other considerations as well. We reached out to Rodney, which is Mr. Grant's brother. Rodney confirmed an address. Mr. Grant has been living at that address stably for over 6 years. If the court placed Mr. Grant on house arrest, he would be able to comply with that. We understand that sometimes the court gives that as an option, but it's impossible for somebody to comply. But Mr. Grant is a good candidate for house arrest because he has been stable for that long. And he has a stable phone number, which is also a consideration when considering house arrest. Mr. Grant is also willing and able to comply with any conditions that the court deems are appropriate, including but not limited to no contact with minors. Obviously, a no contact order pursuant to statute we would submit to with these 2 girls and their families. Mr. Grant would also be able to comply with drug and alcohol testing if that's something that the court feels is necessary, despite the allegation here not being that he was intoxicated. He is a veteran from the Navy. It is true that he was discharged honorably and has full benefits. He survives off of his Social Security and VA benefits. It is imperative for Mr. Grant to contact through the VA, this nation's finest organization, so that they can help him secure counsel and representation for this process. It is Mr. Grant's wish to figure out a way for them to represent him. And that's difficult, obviously, from in custody. There are conditions that we can impose besides no contact with minors and no contact with these girls specifically. Mr. Grant is willing and able to stay off of the internet and to not have contact with minors through any electronic means either. So with that all being said, I'm sure the court heard Mr. Grant has about $1,000 to his name right now to contribute towards legal representation and any other expense. And depending on the likelihood of conviction, Mr. Grant will need to put his affairs in order. So we would ask that the court consider releasing him in the short term at least, so that he can get some logistics taken care of.
All right, thank you. The state has shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. And I'm not been presented any evidence-based, least restrictive means that will sufficiently address the risk the defendant poses. I wish we could take him at his word that he wouldn't do this again, but unfortunately, there's no studies that indicate that sufficiently reduces this type of risk, or the other things that I've been presented, house arrest and residential confinement and so forth. So the bail will be set at $500,000, no contact with the victims. Separate criminal offense pursuant to NRS 1784845 for the maximum 120 days. Also no contact with any minors. Pretrial services supervision. No bail laws, make all court appearances July 24th at 9:30 a.m. is the defendant's next court date. We've seen that.
10%.
Yes.
Your Honor, did you say that there was a 72-hour hearing in the middle of the week?
July 24th is when I said it. For next Friday is when the complaint should be due.
Yes.
And then we'll see him sooner if the complaint comes in sooner. All right, anybody else up for the job?
No, Your Honor.
Have a great day. Thank you.
Thank you.